All right, good evening, folks. Welcome to Monday Night Live, episode 8. I'm going to be covering the consumer fraud protection, which was created by Donald J. Trump, July 11th, 2018. And then Christopher Hallett's going to join me for the last half of the show tonight. And we're going to go over habeas corpus. So this is going to be a really good informative show tonight here. So make sure you get this shared. Hi, Rosa. Hi, Shannon. Hi, Darlene. Hi, Michael, Bill, Melissa, Brenda, Russell. Get this pulled up over here. Shared and pulled up. Then we'll get started. All right, we are live. That's good. Come on. Okay, there we go. All right. So did y'all have a good weekend? Hi, Rusty. Hi, Doug. Hi, Ruby. I'll go over here. Pull this up. All right, I think I got it. Yep. All right. So, I'll grab this here. That's reorganizing. There's the manual, courts martial. Okay, there it is. Actually, I'm going to bring up one more. We have a little bit. You know what? I think I might just start at the very beginning so you guys get a little bit better understanding of what's actually going on. Lay out this timeline so that we can comprehend what Trump has done, whether you like Trump or not. I'm going to show you evidence of what Trump has done, what he's put in place. Some people call it the plan. I call it the law. This is what he has actually done. That's the reorganization. Here's the manual for courts martial. Then, where's the one where he's going? There we go. Okay. So we'll start with this one. All right. So now, for those of you who've been following Christopher Hallett long enough and have read his documents that he has put out over time now, you might see a coincidence in some of the dates of what's going on here. So this is December 8th, 2017. By proclamation, President Trump reestablishes the rule of law. Okay. Our great country was forged in the fires of a revolution to overthrow the rule of a tyrant by a free people who understood the fundamental truth that liberty is best secured when the state's power is carefully limited. From the Declaration of Independence to the Constitution and through the Bill of Rights, our country and our people have always known the true God-given nature of liberty and the ability of law to safeguard it against the state, against government, period, not just the state. But for 226 years, the final piece of this freedom-sustaining bulwark, the Bill of Rights, this is why the Bill of Rights applies to the states, because it's a Bill of Rights, has formed the bedrock of the constitutional protections every American holds dear as their birthright. Right? Bills of Rights are just merely declaratory of the common law. This isn't like something new. These rights were antecedent to the Constitution before creating government. These rights were already there, right? Supposed to be self-evident at this particular point in time in 1776 through 1789, 1791. All of those rights and everything in there, that's all supposed to be self-evident at that particular point in time. But as was said there in the Constitutional Convention and doing the Bill of Rights, that, you know, there's so many rights to enumerate, it might cause some problems there with enumerating some and not enumerating all of them. And it's just too many to enumerate. This was Madison talking and the arguments that were brought there. So, yeah, you know, so these rights are antecedent to the Constitution. You know, that's when we talk about American Jurisprudence, Volume 16, Constitutional Law, Section 100, where bills of rights are merely declaratory of the common law. This is the law, the fundamental law, the bedrock, right? The bedrock that every American holds dear as their birthright. These are called natural rights. And natural rights and civil rights have nothing to do with the establishment, support, or management of government. That's not what we instituted government to do. That's not what it says in the instrument that created it, the Constitutions. On Bill of Rights Day, we recognize the importance of the first 10 amendments to our Constitution to protecting our liberty and freedom against the inevitable encroachment of government. Our founding fathers understood the threat of expansive, omnipresent government from the beginning of our republic. Therefore, they endeavored to enhance the Constitution. That's where we get constitutional republic, with a Bill of Rights, a specific enumeration of fundamental rights that would prevail even against a future government inclined to abuse the power it has over the lives of citizens. What the hell's going on today? They're doing exactly that, which is what Chris has said in his paperwork, is that they've taken the Declaration of Independence and more specifically the declared acts of known to tyrants of tyranny, declared acts of tyranny. Hi, Valerie. Good to see you on here. That those rights, right, are retained by the people, and they're not supposed to be subverting that. That's not the powers delegated to government. They don't have the power over the people. They only have power over themselves as a servant. Servants do not dictate to the people what their rights are and how they exercise them. On June 8, 1789, James Madison, exactly what I was just talking about here, originally skeptical of the need for a Bill of Rights. Why? Because they were already self-evident at the time. Introduced in Congress several amendments to the Constitution that would eventually form the Bill of Rights. During the ensuing debates, Madison told Congress that because all power is subject to abuse, it was worth taking steps to ensure that such abuse may be guarded against in more secure manner. Many of the rights set forth in the amendments Madison introduced that day are quite familiar to us as Americans. The right to worship as we please, the right to speak our minds and consciences, right? The right to firearms to protect ourselves and our loved ones. That's a right. Congress shall not make law That's right. That's why it says shall not be infringed. And the First Amendment says Congress shall make no law. The right to be free from unwarranted government searches and seizures. The right to a jury of our fellow citizens when accused of legal wrongdoing. Others, like the right to object to housing troops in our homes during peacetime. Why are we housing police officers in our homes? We're not supposed to have standing armies. Isn't that exactly what's happening? Our tax dollars are being spent to pay police officers, to pay their mortgages on their homes. Are we not housing troops during peacetime? Sure seems like it to me. Are often thought as relics of a bygone era. Yeah, well, the Constitution's a living document. We can alter that. We can change that. You know, it's so old. We need to change it. No, we're talking about fundamental principles of law, just like fundamental principles of mathematics dictate the correct answer every time. Try changing some of the principles of mathematics: the plus sign, the minus sign, the multiplication sign, and the division sign. Fundamentally, principally, you cannot alter those principles of mathematics without completely destroying mathematics. Therefore, you cannot alter the fundamental law. Fundamentally, principally. So, regardless of their familiarity or applicability to our daily lives, right? Irregardless of that, we don't care about your feelings or whether you know about them or not. However, each clause of the Bill of Rights addressed profound and real abuses the founders faced, and each is crafted and locked into law. That's right, because Declaration of Rights, a Bill of Rights, lays down the law to protect us and future generations from their repetition. Because of everything that they went through at that particular point in time, right? There was a serious war there, right? The Revolutionary War. So with everything that they went through, those real abuses, that is why they wrote the Declaration of Independence the way they did. That's why they wrote the Constitution the way they did. We're not supposed to have parties. We're not supposed to have a Republican Party and a Democrat Party or anything else. That's what they eliminated with this style and form of government. It's like going to work at McDonald's. You want to be the, you know, you've been hired to work at McDonald's. Your duty for the day, performance of your duties, right, under your emolument there, is to be the fry cook. You go wandering around outside doing your other things and not inside cooking on the fry cook, being the fry cook, making fries, you're going to get fired. That's reality. You don't want to perform your duties under your employment contract, you're fired. It's called impeachment. Since its adoption, the reach of the Bill of Rights has spread far beyond America's shores. Why? Because America was the leader, right, in freedom, liberty. The Great Charter of Liberty, that would be the Magna Carta. As George Washington rightfully said, liberty, when it begins to take root, is a plant of rapid growth. For example, in the wake of the devastation of World War II, the spirit of the Bill of Rights inspired the United Nations General Assembly to adopt the Universal Declaration of Human Rights, 1948. Okay, we didn't actually sign on to that until 1993, with the caveat, whatever you want to say that the first 27 clauses, articles, whatever, don't apply unless you invoke them. So if you're going to refer to the Universal Declaration of Human Rights, you are going to have to make sure that you invoke those first 27 articles. Just like the Bill of Rights, the Universal Declaration of Human Rights is grounded in the recognition that just governments must respect the fundamental liberty and dignity of their people. By enumerating core rights, oh wait, rights is law. That's right, rights are the law that should be immune from government encroachment. Both the Bill of Rights and the Universal Declaration of Human Rights have helped fuel remarkable prosperity and achievement around the world. Great. Well, let's take care of America here, because that's where we are. We're in America. During this time, Human Rights Day, Bill of Rights Day, Human Rights Week, we rededicate ourselves to steadfastly and faithfully defending the Bill of Rights and human rights. Our God-given fundamental rights are soon overcome, if not safeguarded, by the people. This is where he was talking about putting all the power back into the people's hands at the inauguration speech. Okay. We therefore also reflect upon many individuals who are unable to enjoy the God-given rights that we as Americans know are secure. Do we know that those are secure? Don't you have to know what your rights are in order to know that they're secure, and how to secure them, how to effectively defend them? Welcome to Kirk's Law Corner. That's what we're doing. We remember those suffering under the yoke of authoritarianism and extremism for doing nothing more than standing up to injustice or daring to profess or practice their religion, and we acknowledge those imprisoned or in peril simply because of their political views or their sex. All right? Now, therefore, I, Donald J. Trump, President of the United States of America, by virtue of the authority vested in me by the Constitution and the laws of the United States, do hereby proclaim as Human Rights Day, I call upon the people, here it is, I call upon the people of the United States to mark this observance with appropriate ceremonies and activities. Let's get active, folks. Petition of Remonstrance. 8th day of December in the year of our Lord, 2017, and of the independence of the United States of America, the 242nd. Okay? Now, let's go to the next one. This is the executive order blocking the property of persons involved in serious human rights abuse or corruption, human trafficking. This is the human trafficking executive order that we have in those petitions of remonstrance that we're basing this stuff off of. Okay? This is it. By the authority vested in me as president, by the Constitution and the laws of the United States of America, including the International Emergency Economic Powers Act. Here's the law he's acting under. He cites the law. The National Emergencies Act, there's the law. The Global Magnitsky, whatever, Human Rights Accountability Act, there's the law. Okay. The Act, Section 212F, that's actually, of the Immigration Nationality Act of 1952, 8 U.S.C. 1182F. Okay, and Section 301 of Title III of the United States Code. President Trump, right? Find that the prevalence of severity of human rights abuse and corruption that have their sole source in whole or in substantial part outside the United States, such as those committed or directed by 13 or persons listed in the annex this order, have reached such scope and gravity that they threaten the stability of international political and economic systems. Okay, it does affect our economy and our political system, right? Human rights abuse and corruption undermine the values that form an essential foundation of stable, secure, and functioning societies. Have devastating impacts on individuals, weaken democratic institutions. Now, remember, this is a worldwide executive order. There's a lot of democratic institutions out there. Degrade the rule of law. Perpetuate violent conflicts. What is the duty of the commander-in-chief of the Army and Navy that go against domestic violence? Foreign and domestic invasion, or foreign and domestic violence. Facilitate the activities of dangerous persons and undermine economic markets. The United States seeks to impose tangible and significant consequences on those who commit serious human rights abuse or engage in corruption, as well as to protect the financial system of the United States from abuse by these same persons. Notice that we're talking about the financial system and corruption and human rights. This is what I'm talking about. The consumer fraud protection in the financial realm of things for emoluments violations. I therefore determine that serious human rights abuse and corruption around the world constitute an unusual and extraordinary threat to the national security, foreign policy, and economy of the United States, and I hereby declare a national emergency to deal with that threat. Sorry, folks, national emergency's already been declared, right? Right there. So here's all this fancy stuff in here. Who it applies to and all that great stuff. Okay. Let's see. Where is, I think it's section 6. There's section 2, section 3, section 4, 5, section 6. For the purposes of this order, the term person means an individual or entity, corporations. The term entity means partnership, association, trust, joint venture, corporation, group, subgroup, or other organization. There you go. This does not apply to us, the man, the people, right? The term United States person means any United States citizen, permanent resident, alien, entity organized under the laws of the United States or any jurisdiction within the United States, including foreign branches or any person in the United States. Well, we'll have to agree to disagree that this does not apply to the people. But for those persons whose property and interest in property are blocked pursuant to this order, who might have a constitutional presence in the United States, I find that because of the ability to transfer funds or other assets instantaneously, prior notice to such persons or measures to be taken pursuant to this order would render those measures ineffectual. I therefore determine that for these measures to be effective in addressing the national emergency declared in this order, there need be no prior notice of a listing or determination made pursuant to this order. Okay. Now let's jump into this next one. Here's the amendments. Amendments to the Manual for Courts Martial, March 1st, 2018. By the authority vested in me by the President, the Constitution and the laws of the state of Idaho, or state of Idaho, pardon me, state of America, including Chapter 47 of Title 10, the United States Code, Uniform Code of Military Justice, 10 U.S. 801 through 946. See, he's citing the law that he's acting under to execute the law that Congress made. And in order to prescribe amendments to the Manual for Courts Martial, United States prescribed by Executive Order 12473 of what? April 13th, 1984. So he dug up this executive order from 1984 and amended it. It is hereby ordered as followed. Part 2, 3, and 4 of the Manual for Courts Martial United States are amended as described in Annex 1, which is attached to and made part of this order. Section 2, the amendments in Annex 1 shall take effect on the date of this order, subject to the following. Nothing in Annex 1 shall be construed to make punishable any act done or omitted prior, this would be ex post facto law, to the date of this order that was not punishable when done or omitted. Okay? Nothing in Annex 1 shall be construed to invalidate the prosecution of any offense committed before the date of this order. In other words, what Trump is doing is he dug up this executive order and he's going, hey, under this national emergency, we can go through court martials, right? Military tribunals. This is already in the law. Been there for a long time. It's the way it is. He's just bringing it up and executing it. Something none of our past presidents have ever done. None of our past presidents have ever brought this up and used military tribunals to go after people involved in serious human rights violations, human trafficking, and corruption. Maximum punishment for an offense committed before the date of this order shall not exceed the maximum punishment in the effect of the time of the commission of such offense. There he is talking about the ex post facto clause of the Constitution. Although he knows he's made the amendments here, he knows that he can't change the law after the fact. So all these crimes, basically, he's telling the executive branch to go after these bad actors or, you know, people involved in serious human rights violations, corporations, entities, what have you, that are involved in human trafficking, corruption, all that stuff, that they have to go by the law at the time that they committed the crime. Now, if these crimes are committed after the date of the amendment on this, well, nothing in Annex 1 shall be construed to invalidate any non-judicial punishment, proceeding, restraint, investigation, referral of charges, trial in which the arraignment occurred, or other action begun prior to the date of this order, and any such non-judicial punishment, proceeding, restraint, investigation, referral of charges, trial in which arraignment occurred, or other actions shall proceed in the same manner and with the same effect as the amendments in Annex 1 had not been prescribed. So everything that's already been started prior to Annex 1 and the date of this executive order has to go based on the law back then. Okay, that's how that works. Pursuant to Section 5542 of the Military Justice Act of 2016, I wonder who did that. Who did that Military Justice Act? That'd be under Obama. Division E of the National Defense Authorization Act for fiscal year 2017, public law. That's right, they're allowed to make public law. There's the law, except as otherwise provided by the MJA, which is that Military Justice Act, or this order, the Military Justice Act, shall take effect on what? January 1st, 2019. January 1st, 2019. January 1st, 2019. All of the amendments and changes all became effective January 1st, 2019. Manual for Courts Martial, United States, as amended by Section 1 of this order, is amended and described in Annex 2. Okay. Shall be construed to make punishable any act done or admitted prior to January 1st, 2009 that was not punishable when done or admitted. So nothing in here can do that. But afterwards, you're in deep doo-doo. Okay. Nothing in Section 4 of Annex 2 shall be construed to invalidate the prosecution of any offense committed before January 1st. So in other words, well, it don't matter when you committed it, you're still going to be prosecuted. And he's executing the law, and he's telling people in charge there to start following the law and execute the law and do this. I don't care if those crimes were committed before this order or not. Follow the law prior to it. Either way, let's bust their ass and get them done. So this is all just a bunch of, stuff that probably doesn't make a whole lot of sense to a lot of people. But the fact is he made amendments to the manual for courts martial to use military tribunals to go after all these sealed indictments, right, around the world, right? This is not specific to just the people in the United States of America. Ginger, these documents are already uploaded into Kirk's Law Corner, the group in the files section. Each and every one of these. I already got these into a PDF file that you can download, print out, and attach with your documents. They're already there. Already done that work for you, folks. All right. So this was March 13th, 2018. My administration will focus on ending the absolutely horrific practice of human trafficking, and I am prepared to bring the full force and weight of our government, whatever we can do in order to solve this horrific problem. Again, March 13th, 2018. Okay? Human trafficking is a front to human dignity, with millions affected worldwide. Human trafficking is a global atrocity that deprives millions of their universal human rights. Human trafficking, also known as modern slavery, affects people from all backgrounds, at home and abroad, placing millions into sickening form of exploitation. Per the International Labor Organization, there may be as many as 24.9 million victims of forced labor across the world, with millions going unidentified and unseen. These are the ones they know about, right? Children are especially vulnerable to this evil practice as they account for 25% of the modern slaves. Victims are compelled to perform labor or commercial sex acts. Labor. Keep this in mind, because there's two parts to human trafficking, folks. Okay? Two parts here. Through the use of fraud, force, or coercion, reducing the value of human lives to that of mere commodities. The United States is a source, transit, and destination country for men, women, and children, both United States citizens and foreign nationals, victimized by human trafficking. In fiscal year 2017, Department of Homeland Security, Immigration and Customs Enforcement, Homeland Security Investigations, initiated 833 human trafficking cases, resulting in 1,602 arrests, 578 convictions, and identified 580 victims of human trafficking. That's in the very beginning of 2017. Okay. The HHS funded National Human Trafficking Hotline received reports of 8,686 unique cases of potential trafficking in fiscal year 2017, identifying 21,644 potential victims. This would be the National Human Trafficking Hotline. Annual illicit profits from human trafficking were estimated to be as high as $150 billion in 2014, demonstrating the substantial economic scale of this abhorrent criminal industry. Protecting the innocent, President Donald J. Trump is taking a stand against human trafficking, dedicating our government's full resources towards fighting this repulsive crime. The President's Integrity Task Force to monitor and combat trafficking in persons is working tirelessly to address all aspects of human trafficking. As defined by the Trafficking Victims Prevention Act, it is the policy of the United States government to address human trafficking via the 3 Ps: prosecution of traffickers, protecting of victims, prevention of human trafficking. All right? There's your 3 Ps, PPP. In March 2018, the president appointed 9 human trafficking survivors to serve on the U.S. Advisory Council on Human Trafficking for terms of 2 years. President Trump declared January 2018 National Slavery and Human Trafficking Prevention Month. September of 2017, Ivanka Trump and Deputy Secretary of State Sullivan joined more than 20 world leaders at the United Nations General Assembly for a global call to end modern slavery and to announce the State Department's $25 million grant to the Global Fund to End Modern Slavery. In February 2017, the president signed Executive Order, what's that, 1377, enforcing federal law with respect to transitional criminal organizations and preventing international trafficking. This order directed the United States government to identify, interdict, disrupt, and dismantle the transnational criminal organizations that engaged in human trafficking. Totally abolish that crap. In light of the impending Senate vote on the Foster-Sesta legislative package designed to fight online sex trafficking, the Trump administration is hosting a roundtable on human trafficking to review and discuss the path forward on this critical issue. And let's just cover one more little thing here. Understanding human trafficking. Here we go. This is the law here, right? This is the help here. Office of Justice Programs, OVC. This is the Office for Victims of Crime, Training and Technical Assistance Center. By the way, if you'd like to be a human trafficking corporation and get into this, you can get training right here. You can form your own task force to go after human trafficking. Did you know that? Power of the people here, folks. All right. Let me turn some light on. It's starting to get dark over here. Okay, so this is under Section 4, what I have pulled up here. This part that I'm going over right now is actually under Section, I believe, Section 4, wasn't it? No, okay, this is Section 1. Understanding human trafficking, right here in the very beginning. While existing data are not sufficient to fully identify the extent of human trafficking in the United States, current research indicates that many law enforcement agencies in the United States have encountered some form of human trafficking. Imagine that. You've encountered some form, right? Think we ought to do something about that? I think we should. Or contacted victims through routine work and investigations into other crimes. So while investigating other crimes, they found human trafficking. Victim service providers may also come into contact with trafficking victims in a variety of settings. Due to the complex nature of the crime, perpetrators often operate unnoticed, and those who suffer are not likely to self-identify as victims of human trafficking. Well, yeah, because I'm not being trafficked sexually. I'm not having to perform any sexual acts, so I'm not being human trafficked. Not true, okay? Trafficking victims does not always see themselves as victims, often blaming themselves for their situation. What's that called? Stockholm syndrome, okay? Get even to the point where they turn to love their oppressors, their kidnappers, whatever. This makes discovering this crime more difficult because victims rarely self-report, and the time and resources required to uncover violations can be significant. So we can help out with that. Too many victims are misidentified and treated as criminals or undocumented migrants. In some cases, victims are hidden behind doors in domestic servitude in a home. In other cases, victims live in plain view. Here we go. Live in plain view and interact with people on a daily basis. CPS, judges that aren't judges, they're administrators. Yet they experience commercial sexual exploitation or forced labor under extreme circumstances in public settings. Then they go, oh, well, exotic dance clubs, factories, or restaurants, and are not identified due to lack of identification, training, and awareness. So, you know, they kind of skirt around some of this other issue, but it's laid out right here in the law. According to the federal legislation, the Trafficking Victims Protection Act, right here, that's in this executive order right here that he's talking about. Right there. Okay, that's this right here. What we're talking about. Okay, this is part 1A. Sex trafficking, in which a commercial sex act is induced by force, fraud, or coercion, or in which the person induced to perform such act has not attained 18 years of age, or this is part B of human trafficking. The recruitment, harboring, transportation, provision, or obtaining of a person for labor or services through the use of force, fraud, or coercion for the purpose of subjecting to involuntary servitude, peonage, debt, bondage, child support, spousal support, all those unjust enrichments, or slavery. There it is. Part B of human trafficking. That peonage, debt bondage. Right? That's why we did that breaking news back in the day when Jeff Sessions came out in November of 2017 with the prohibition on the use of guidance documents, right? Child support guidelines created by who? The executive branch, the Department of Health and Welfare, more specifically, Child Support Division. Okay, since when does the executive branch have the power to make law? No, that's a guidance document, guidelines, child support guidelines, child support guidance document, going from the executive branch over to the judicial branch and dictating to the judicial branch how to make their rulings, right? That's a guidance document. That's prohibited in our form of government. That would be the executive branch exercising powers belonging to the legislature. And the legislature, what? Does not have the authority over that subject matter jurisdiction. Natural rights have nothing to do with the establishment, support, or management of government. That's also in Kirk's Law Corner group. Prohibition on guidance documents. Okay, so yeah, this is about the money side of things. Court fees, right? Or well, let's see, Magna Carta, number 40. To no man will we sell, to no man will we deny, defer rights or justice. Idaho Constitution, we will not sell nor deny or defer rights or justice. Justice is not for sale. Selling justice for money is barratry. Bad news there, folks. Human trafficking often involves severe violence to its victims. You don't pay, we're going to throw you in frickin' jail. They're out there frickin' busting people's doors down and arresting people for failure to pay child support, which is an unlawful order to begin with, which, right back to what I was just saying, right? Along with a host of other crimes, including gang, drug, and property crimes, stealing your property. Organized criminal operations. Would that be a declared act of tyranny? To send hither swarms of officers to eat out our substance? What does that one say there? Let's just read it, because that's the one of the ones that we're using in our petitions of remonstrance, right? Where is it? Probably should break out my highlighted one so I know exactly which one it is, but maybe it's right here. He has combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, given his assent to their acts of pretended legislation. Okay, Juvenile Protection Act, the child support guideline documents, those are outside of the jurisdiction. That jurisdiction is foreign to our form of government, foreign to our Constitution. He has kept among us in times of peace standing armies without the consent of our legislature. Here it is. He has erected a multitude of new offices and sent hither swarms of officers to harass our people and eat out their substance. That is human trafficking. That's also foreign to our Constitution and unacknowledged by our laws. Those are unlawfully created emoluments. Those offices, easy emoluments of statutable plunder. How is it not treason? Exactly, Alan. It is treason. It's a declared act of tyranny. So these are acts only known to tyrants, which is our declared enemy. Anyone who takes these kinds of actions is our declared enemy. That is giving aid to our enemies. That is capital felony treason. Sedition, subversion. Again, Title 18, 2381 through 2385. United States Code. Okay? So now you know all that. That's all right, Diana. See, I'm creating these episodes here so that people can come back and rewatch these. I know that I'm doing this fast. That's just how my brain works. You know, I'm the 125 mile an hour. You know, my brain just just goes like crazy. So this is a great website right here. And in fact, I'm going to go ahead and copy and paste this right into the feed right now. So you all can have that as a good reference. Maybe you'd like to start your own human trafficking task force. All right, there we go. That's shared out there now. Okay. So, oh yeah, you get to see that. Now, we're going to go to the end all be all here, which would be just about right. About another 15 minutes on this. Okay. Here's the executive order from July 11th, 2018. Executive order regarding the establishment of the task force on market integrity and consumer fraud. Now, the reason why I went back and did all this from the beginning is so that you could see the timeline and how this is set up and how this applies to everything that he's already done. Okay? By the authority vested in me as president by the Constitution and the laws of the United States of America, in order to strengthen the efforts of the Department of Justice, federal, state, local, and tribal agencies, right, even to the Indians, to investigate and prosecute crimes of fraud committed against the U.S. government or the American people, recover the proceeds of such crimes, and ensure just and effective punishment of those who perpetrate crimes of fraud, it is hereby ordered as follows. The Attorney General. This is the establishment of the Joint Task Force on Market Integrity and Consumer Fraud. Okay? So, under that executive order for serious human rights violations, corruption, human trafficking, that's what this is right here. Emoluments violations, folks. Financial, any advantage, profit, or gain received due to one's position of employment or holding public office. The task force shall include the following members. There you go. Deputy Attorney General shall serve as the chair. The Associate Attorney General, who shall serve the vice chair. The Assistant Attorney General for the Criminal Division. The Assistant Attorney General for the Civil Division. The Assistant Attorney General for the Tax Division. Here you go. Antitrust Division, Chris. Federal Bureau of Investigation. The United States Attorneys designated by the Attorney General and such other officers or employees of the Department of Justice as the Attorney General may from time to time designate. Okay, so it is through the Department of Justice, but it goes through the executive first because the executive does the investigation, right? This is the process to prosecute going through the Department of Justice. Okay, military tribunals. The Deputy Attorney General shall convene and direct the work of the task force in fulfilling its functions under this order. The Deputy Attorney General may permit, when appropriate, the designee of a member of the task force, including participants invited under Section 3 of this order, and we'll get to Section 3 here in a second, to participate in lieu of the member or participant. What was that over here? You want to create your own joint task force, forming a task force? You come here and check that out, and you can form your task force. This lines it all out, how to do it. Whatever field part you want to go into. Okay? This can be done. We can do this. From time to time, Okay, joint versus the time Deputy Attorney deems appropriate, right? In lieu of the member or participant. Well, let's get to those. Who are they talking about in lieu of? Exactly what I just showed you. You can create your own task force. In the task force performance of the functions set forth in subsection 4A and C of this order, and to the extent permitted by law, the Attorney General or the Deputy Attorney General and his designee shall periodically convene meetings and shall invite participation from the following senior officials from executive departments and agencies, or their designees, as well as such other officials the federal government as Attorney General or Deputy Attorney General deems appropriate. Here are some of those people. You ready for this? The Secretary of the Treasury, the Secretary of Defense, the Secretary of Health and Human Services, the Secretary of Housing and Urban Development, Secretary of Energy, Secretary of Education, Secretary of Veterans Affairs, Secretary of Homeland Security, the Administrator of Small Business Administration, the Chairman of the Board of Governors of the Federal Reserve System, the Commissioner of Social Security, Administrator of the United States Agency of the International Development, Director of Bureau of Consumer Financial Protection, Chairman of the Federal Trade Commission, Amanda, the Chairman of the Securities and Exchange Commission, the Administrator of General Services, the Chairman of the National Credit Union Administration, Chairman of the Commodity Futures Trading Commission, Chairperson of the Board of Directors of Federal Deposit Insurance Corporation, Director of the Federal Housing Finance Agency, the Comptroller of the Currency, the Chief Postal Inspector of the Postal Inspection Service. That's a good one. Mail fraud. These jackwagons sending you documents through the mail, the fraud through the mail. There's one that you can go and talk to and inform him of these people sending that fraud through the mail. Okay. Now, Section 4 consists with authorities assigned to the Attorney General by law and other applicable law. The task force shall provide guidance for the investigation and prosecution of cases involving fraud on the government, the financial markets, and consumers, including cyber fraud and other fraud targeting the elderly. Brenda Johnson, including fraud and other fraud targeting the elderly. Gonna need to look that up there. Service members and veterans and other members of the public, procurement and grant funds, securities and commodities fraud, as well as other corporate fraud, CPS is a corporation incorporated into the corporate charter, right? With particular attention to fraud affecting the general public, digital currency fraud, money laundering, including the recovery of proceeds, healthcare fraud, tax fraud, and other financial crimes. Them orders to pay fines, them orders to pay child support. Now, don't get me wrong. I think parents should support their children, but let's define what support really is. Support is love, care, and nurturing of their child. It is not a monetary gain for the other side. And there's a legal maxim behind this, a maxim of law, a rule of law. No one shall be enriched out of the loss of another. You cannot deprive the exercise of the fundamental right to provide support, love, care, and nurturing for their child. On one hand, deprive them, and then enrich yourself. That's the negative, right? The negative nexus, proving a negative here. That's what I'm doing. You got people like me who have been deprived of my fundamental right as a father to provide that love, care, and nurturing to my child, to my son, and then be ordered to pay for that. I don't think so. That would be an unjust enrichment. You were depriving the fundamental right first without due process of law and under color of law, and SMU, not only that, under the law from 1994 that was overturned in 2000 by the Supreme Court of the United States of America. You can't have full faith and credit from something from 1994 that was amended It was found to be unconstitutional in 2000 as it violates what? The Commerce Clause, Article 1, Section 8, Clause 3. The federal government only has specific jurisdiction over commerce. That shit doesn't apply inside the borders of a state. Federal law only applies to those that are bound by it. The people inside the borders of the state are not bound by that. Public officials are bound by the Constitution of the United States of America. Article 6, Clause 3. No matter what branch of government you're from, you shall be bound by oath or affirmation to support this Constitution. And any corporation, right? Any corporation that incorporates themselves into the corporate charter is what? Constitution of the state of Idaho is the corporate charter. Every corporation organized for any lawful purpose or purposes, it must be lawful. No such thing as legal. Has to be done lawfully in accordance with the Constitution of the state of Idaho and the Constitution of the United States of America and the Declaration of Independence, because that's what those constitutions ultimately secure, is those rights, right? Whether a general business corporation or a designated class of corporations, what would that be? Designated by the state of Idaho, or whatever state you're in, right? Or the Constitution of the United States of America. There are designated classes of corporations. Okay? Shall, not may, it is shall. By the act of filing incorporation documents, your business license, when you, that's why we have to understand license here. License is seeking permission to do a thing that would otherwise be illegal. Okay? When you apply for your business license, you're seeking permission to carry on your business as a corporation that is incorporated. Those incorporation documents, that's your business license. That's your incorporation documents with the state of Idaho, right? Acknowledge and accept the provisions of the Constitution of the state of Idaho as binding upon that corporation. This is called the law of creation. We, the people, created the Constitution of the state of Idaho. Then what's inside that creation? We created what? The governor, the legislature. You know, we created the legislative branch, the executive branch, and the judicial branch. We ordained or established through the Supreme Corporate Charter, Supreme Law of the land, regarding process for bringing things into being. That's how we did that. That's the law of process, right? And they incorporate themselves into the corporate charter and are bound by it. So this is why I want to talk about consumer fraud. These corporations are incorporated into the state, no matter how you want to look at it. Okay. You have, let's go with CPS. It might be a privately owned corporation, but it is incorporated into the public, and it is bound by the corporate charter. Plain and simple, the law of creation. The people created the Constitution. The Constitution allows the creation of the legislature. The legislature allow these licenses, business license, to operate their business inside, whether they want to be a public corporation or a private corporation, which would still be a private public corporation. When we're talking about private, that would be the Hale versus Henkel case. What we do in private contracts, that would be a private contract between me and another man, not between me and the state. That's the private. The private public would be me creating the contract of the business called CPS, and I'm receiving funds from the Department of Treasury, which makes me a public corporation. I don't care if it's owned privately. The fact of the matter is you are incorporated into the state corporate charter and are bound by the law of this nation, pursuant to the supreme law of the land. Okay? So this is on my site. I just punched in Idaho Consumer Fraud Protection. This is the page that I come up with. Okay, actually it was this one here, but I clicked on that other part there and it brought me to this one, and it says, I would like to file a complaint. There's a drop-down box here. I'd like to ask a question. I'd like to file a public records request. This is the FOIA. Okay, it's Idaho. Okay, I want to file another drop-down box. Charitable organization complaint, consumer complaint, Medicaid fraud complaint, public corruption complaint. Yeah, I want to do a public corruption complaint. Now, this is where it says, oh, click here to down explanation and duties and responsibilities. So I clicked on that. Explanation of duties and responsibilities. Before filling out the form, please read the following sections carefully. Idaho Code, okay. County prosecuting attorneys and county sheriffs have primary responsibility for enforcing Idaho's criminal laws. Who? The prosecuting attorneys and the county sheriffs. As a rule, the Attorney General may investigate and prosecute cases at the county level only when a statute grants the Attorney General concurrent jurisdiction or when local authorities request assistance for a specific case. That's not exactly true, because we found out that the process that's per the Constitution, the Bill of Rights, is we go to the legislature and we demand that the Senate order an investigation for criminal indictments, which would instruct the Attorney General to do an investigation. So what we're thinking here is we want to combine the petition of remonstrance with this deal here and a habeas corpus. So we're trying to figure out ways to make this short, sweet little pieces that we can put together that's not going to be as big as what Chris has been doing or as big as what John is doing, right? We're trying to break this down to make it easy. And there's a form here. I'm going to get to that. However, Idaho Code 31-2002 gives the Attorney General the authority to investigate alleged violations of state criminal law by elected county officials and who are acting in their official capacity. Well, Mr. Title 31, Section 2002, you might want to read this executive order creating your capacity, this agency that President Trump created, because that's what you go after now. Human trafficking and all that other crap, the 3 Ps, okay? That's what you were created for. So, upon completion of an investigation as such, a complaint must meet all 3 of these criteria for the Office of the Attorney General to investigate. Upon completion of an investigation into such allegations, the Attorney General may A, issue a finding that no further action is necessary, B, prescribe training or other non-judicial remedies not involving the filing of criminal charges, or conduct further investigation and retain the matter for prosecution. This is where we get to go in and instruct our representatives. You will conduct further investigation and retain the matter for criminal indictments through military tribunals at this particular point. because now that's effective. Okay. What violations does the statute cover? Well, I don't care about your statute. Authorizes the Attorney General to investigate alleged violations of state criminal law by county officers holding elective office. That's funny. That's not what it says here. It says everyone. And that would go back to this one, right? Anyone. Partnership, association, trust, joint venture, corporation, group, subgroup, or other organization. That's per the executive order. Let's follow the law here, what you've been told to do. So this might be an old, I'm not sure exactly when this came out. There's no real date on it, but applies to allegations involving a county officer occupying an elective office. This includes only the following officers. I don't know. Can you guys see that very good? Maybe make that a little bit bigger. Who can investigate? Where was I at? Investigate alleged violation of state criminal law by county officers holding elective office. This does not include violations of city or county ordinances, acts with which the complaining party merely disagrees. 3, inadequate performance of duties. Oh, really? Policy violations. And 5, acts performed in obedience to or permitted by a court order. The statute specifically excludes investigations into open meeting violations. Well, it's a good thing we don't have to go off of this statute. We can go off of this executive order here, because this statute would be a little vague, right? It doesn't quite cover what we need it to cover. So that's why we have the new joint task force. But as I showed there, it was talking about for public corruption. So this might be an outdated, they might need to update this. Okay. Process for reporting violations. Please complete the online reporting form. Make sure to provide your name, address, phone number, email, blah, 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 blah. Each complaint is reviewed by Office of the Attorney General's staff. If we determine no further action is necessary, you will be informed in as a timely manner as possible. If further action is necessary, a response may be delayed. Why? Because in order to maintain the integrity and fairness of the legal process, our office does not comment on pending investigations, and we are unable to provide any information until investigation and related legal proceedings are completed. Although this should be done in public, right? In the public. So it should be a matter of public record. Let's see. Pursuant to public records law, any complaint form or associated documents become public records when submitted to this office. This office may be required to disclose such documents if requested. All documents submitted become the property of this office. Original submissions will not be returned. So please send only copies of documents if you desire to retain the original. Please, folks, keep your original stuff. Only make copies, okay? And you attach that stuff in there. Now let's take a look at this little 3-page form here. Right? There it is. Consumer complaint form. Right, go into the Attorney General there. Consumer Protection Division. It happens to be right in my state capitol on the 2nd floor. Okay, your name. Now, the one thing I like about this is it's not actually in boxes. So for those of you who know what I'm talking about out there. So this is for Idaho, clearly. So for my Idaho family and friends here we go. Describe your complaint, including names, dates, and actions. What have I been trying to teach you? Short, concise, sweet statements of facts. The who, the what, and the where and when. Who did what, the actions, where, and on what date. Attach additional pages if necessary, like an appendix. Okay? Do not send originals. We will not return them. So, if you lost money, see, and in here I would go see attached documents, because that's inside of a box. And you don't want your stuff being inside of a box because it's not part of the document. So, if you lost money because of this purchase or lease, how much money did you lose? Please explain how you calculated your loss. Okay? What do you think would be a fair resolution of your consumer complaint? The death sentence. No, I don't know. If it involves kidnapping, you can seek the death penalty. So, did the business or person identified on page 1 previously provide you with a written response to your what? Just a hair too big here. Your concerns? So, did you actually contact? Of course you did. Did another office, such as the Better Business Bureau or Department of Finance, previously mediate your complaint? You filed a lawsuit against the business or the person identified. Well, you can actually say yes if you're going to do a petition of remonstrance into the legislature, and that will be attached, right? We're going to do the switching the cover sheets thing, send one over to the Consumer Fraud Protection Agency, switch the cover sheet. It goes into the Idaho legislature, switch the cover sheet, and send it over there to the United States Congress. So every one of them, all three of them know they've all been put on notice of what's going on here. And put your case number in there. But make sure you put in there to the well, when they get the paperwork, they'll get it, right? But you can put in there, yeah, in the legislature, and there's no case number because the legislature doesn't give a case number. Has the court issued an order, judgment, or other final decision in your lawsuit? No. Because the court of justice that you're going into is going to issue an order, judgment, and other final decision in your lawsuit. That suit at law and suit of equity that's inside there. All right. So this particular part, I'm having a little bit of issue with here. Before checking a box, make sure you understand how the Attorney General's dispute resolution process works. And, what is this? Dispute resolution process. This is arbitration. We're going to get into that arbitration. I'm learning about that. That's something going on in the background right now. So, an explanation of this voluntary process is available on the Attorney General's website. Click here and go to that, or the letter that came with this complaint. Please consider my complaint for the Attorney General's dispute resolution process. Well, when we send this over to the legislature and we demand the Senate order an investigation, and it'll come back over here to the Attorney General, the Attorney General will already have a good idea of what's on his plate, and this will be null and void because they're going to get a scope document to investigate all of the people you've listed and whatever court records that are out there, and to investigate all of that stuff for whatever your claims are made, to verify your claims, and then report back to the legislature, to the Senate, what their findings of facts are. Did you find crimes? Did you verify these alleged crimes? These claims of crimes being committed? Well, yeah, we did. Yeah, those are criminal indictments you need to get, huh? Yes, indeed. Yes, indeed. So, other than that, that's pretty much it, folks. And now I'm going to bring Chris on, and we're going to discuss habeas corpus. And that would be, we're going to start with this document. It's also in Kirk's Law Corner group. This document is habeas corpus, writ of liberty, Bomadine 9, whatever, and beyond. Okay. This is from Cleveland State Law, Cleveland State University, College of Law Library, Law Journals, 2009. Habeas Corpus, Writ of Liberty, Bobonine, and Beyond. This is actually a book. Okay? And you can click on these links and you can go there and get more information about it if you want to.
It's easy for you to say. Oh, well, you know, another Monday night, end of a weekend, end of an ending, something like that anyway. So how's everybody's weekend? How are you guys doing tonight?
Doing good, doing good.
Yeah, good deal. Good deal. We are to go over the habeas corpus. This question came up a little earlier today, and I want to make sure that I am looking at the right thing. Okay, here we are. When we talk about writs of habeas corpus, okay, this fundamental right in the state of Florida is Article 1, Section 13. That's where it comes from in our state's constitution. In order to properly execute this, you must claim it lawfully, right? This is the stuff that we talk about here. This was in the form of an initial appellate brief. In my particular case, I always quote mine because, number one, I know it the best. And number two, I don't have to worry about potentially screwing something up from somebody else's constitution that I don't know as well as I know my own. So anyway, that's where the Article 1, Section 13 comes from. Now, kind of break some of this stuff down. Article 1, obviously, is all political powers inherent in the people. Why is this a political question? Well, that becomes right there is the process of where we claim the right. Okay, exercising it we'll get into in a minute. This is where we're just claiming it. These people are claiming that you owe them a debt, whatever the debt is. And if that debt is related to money, if there is a constitutional provision that prohibits these actors from taking an action that they are taking unlawfully, well, again, to make that lawful argument, you have to make that lawful argument in all three branches, right? Because it is a constitutional provision, obviously somebody somewhere along the line went to your state Congress and made a promise, quote unquote, or said, I'm going to perform this function, whatever. Oh, and I know the Constitution. I know the terms and conditions of that employment contract. And obviously they don't. And one of the documents that they use in these cases is what's called a writ of capias attachment. Now, that document is preserved for such things as pyramid schemes, okay, money mongering, white collar style crime. So when they come out and they make these allegations against you, and you're busy fighting the untruths and various other injustices in your case, okay, they're racking up this debt based on a formula that they created, which you have, many of you probably have never even seen it. And the reason you've never seen it is because they have purposefully hidden it. And the reason that they would do that is because they want you to fight with your ex. Okay. And because, again, when you become skilled at this, what you can claim that under is a due process violation. What process are you guys talking about? Because you've made a claim that you can't support, and all those other things that Kirk has discussed here throughout the show. And these are the various constitutional articles that support your standpoint. So this is where you claim them. Okay. Now, what are you pursuing? What are you going after with reference to emoluments violations? Right. Well, I'm claiming that these actions, this actor broke my Florida constitutional right pursuant to Article 1, Section 11, as well as these other ones, but pursuant to an unauthorized practice of law. Why is it unauthorized? Because this actor took an action that he didn't have lawful authority to take. What I cannot do in my person, I cannot do through the agency of another, right? Can't commit a contract, or you can't write a contract to break a constitutional provision of any kind, no more than I could contract somebody to go out and rob a bank and give me the money, right? No, can't do that. That's not lawful. Well, neither can this person, who is quote unquote acting as this attorney who does possess government emoluments, a special privilege in standing in the court, right? Which we talk about, that any advantage, profit, or gain. Well, that advantage, that standing, is an emolument, period. So, and of course, I am standing my ground against further injury or harm. That's this second statute. So this is what I'm pursuing: an authorized practice of law, and I'm standing my ground. So in other words, I hope you brought a tank, because my ass ain't that small. So we're going to further pursue Title 18, subsections 241. That is conspiracy. Number 242, to violate rights under color of law. And 643, use government funds, Title 4, to do that. Okay. So those are the violations. Now, where does this relate to me? Okay. And what E clause does? That's a very good question. Under 2018 USC 1927, this is where we get into who's going to argue over what constitutes an unauthorized practice of law. Well, according to Title 28, 1927, okay, I possess multiple years in experience over what the consequences are of not maintaining the truth in the record, and how that negatively affects public trust in the private sector emoluments of the corporations that I work for. Okay. So under 29 USC subsection 1109, because of my credentials listed here, okay, these emoluments, I actually am statutorily duty bound to report these violations to the appropriate authorities. And as far as I'm concerned, the only appropriate authority I'm aware of is my fellow man. That would be the representatives that we elect in Congress. Okay. So because we already know that these Article 1 tribunals are actually unlawful emoluments, kangaroo courts, he's erected a multitude of new offices, yada, 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 and these different things that we have discussed, these declared acts of tyranny. Those offices are now crime scenes. To further request or demand that I go back to the scene of the crime to pursue justice is not a reasonable request. No sane man or woman could articulate a reasonable cause that I should have to go back and subject myself to further injury or harm willfully. Wrong. Right. So anyway, this is where we get into what are the fundamental principles on which I'm basing this. Res excipiendo fit actor. The defendant by plea or exception becomes plaintiff. And of course, these various other ones, which we'll get into later. Now, again, because we are referring this to not just the court, which is where these actors brought this action. Here's the case number that they brought. Okay. Or actually when I took it to the Court of Appeals, that's the actual case number the Court of Appeals assigned. But I said, because these actors are breaking these constitutional articles and all these various things I just purported, the court recognized that and mandated, okay, you know what? I'm not going to try to argue with you because you're not wrong. They didn't say I was right, but they didn't say I was not, but they didn't say I was wrong either. So again, this is where we get into that word salad. And the judge mandated the case as me versus the Florida Department of Revenue. So, whereas before it was the Florida Department of Revenue versus me in the lower tribunal, quote unquote, unlawfully executed Article 1 court, that's a weapon, right? That weaponized family court. I brought that up down a little bit further down here. Weaponized family court supplement. This is me telling United States Congress, we were still in the 115th at the time. This was me telling the 115th Congress, you've already seen version 1 of this. I'm adding to it. Okay. So we're adding further insult to my injury. So that's basically what I'm telling them on this in this updated petition. So let's go back to Florida. So when I walked into the Florida legislature in the congressional session, here was the joint rules I cited, because remember, I wanted members from both houses. I knew there was going to be some form of congressional action that was going to require either an investigation, a contempt, an impeachment, whatever. But since we hadn't gone through the process yet, we, you know, to actually say what that is would be kind of putting the cart before the horse. So I simply said, okay, until we go through the record, let's use these rules to introduce the record, the court, you know, from what we got out of this case, you know, from this appellate case, into the into the congressional process, again, pursuant to these Florida constitutional articles, pursuing these 2 statutes, these emoluments violations here, and, you know, basically this is me. Here's my corporate veil as a private attorney general. We've already been through all of this, blah, blah, blah. So we went through this entire process, okay? And the end result was the judicial mandate. I'll go over that in a second. But I want to show you guys more specifically that getting this into the Florida Congress required this cover page, right? And this is where I informed, right? Because this Article 1 court was purporting themselves as an executive branch. Here's me informing the executive branch. Here's me informing the legislative branch. Okay. And of course, the 5th District Court of Appeals, by now their head is spinning, going, what in the absolute hell are you guys doing? Right? You can't mistake you. And the answer is they had not established any standing or jurisdiction. Well, of course, we knew that. So, which of course we've covered later on. And this was, again, a supplement, just another amicus case report and supplement to what they've already gotten based on stuff that we already knew and didn't have to go into a whole lot of specificity in that. So this is where, when I walked in and I simply stated that everyone is the manager and disposer of his own matters. That's a maxim of law. In other words, look, I don't need you to tell me what I already know, right? I fathered these children. I know what my responsibilities are. What I want to know is who in the hell are these actors up here to tell me their interpretations of what they think my duties and responsibilities are? Because according to the main articles of practice, that's my job, not yours or theirs or anybody else's. So again, I can say it without even saying it, which is exactly what I do as much as I possibly can. So again, this is basically just, now if you go down through here and you read through the table of contents, every one of these sections in this document does come from the, or not, actually not all of them, but all of the required sections are from the Court of Appeals rules of what goes in a habeas corpus. Things like the preface, those are not required, but because my process in loss prevention reporting to Congress and updating United States Congress, right? My process not only conforms to the minimum standard, but it also goes above and beyond what the quote unquote process these people are purporting, goes way and above what they're already practicing, what they're already doing. Okay. So, again, because this the way I build these things is modular or integrated. This is why I constructed my, my notice of appearance the way I did. Here's my corporate mission statement. Mm-hmm. And to go to what Kirk was talking about earlier, when I established my corporation lawfully, right? There it is. Small business corporations. Here's my filing. And excuse me, E-Clause is a brand new entity filed in the state of Florida, October 12, 2017. This entity was created by Christopher Hallett in response to Executive Order 13781. I won't read you this whole thing. It's out there. I'm sure many of you have already read it. So, in other words, this is me. They've already read this. They know this is out there. So when I came out and showed them later on in the process where I said, oh, yeah, here's my year-end report. Maybe, possibly, could be. There it is. When I filed my actual this will be going into my third year of business. I've completed 2 years. This was my completion of my second year. So they can go through and they can verify that I'm still around. I ain't gone anywhere. And we're still going to go. We're going, and I ain't stopping until I'm confident, until I'm happy that we're done.
Would these be the documents that incorporated yourself into the corporate charter of Florida and the Constitution of the United States of America?
That is correct. To perform my duties under the law.
Yep.
Well, we've already
in
talked
accordance with the law.
Yes, absolutely. Nobody is above the law, right?
Right.
So what I cannot do in my person, I cannot do through the agency of another. I thought that was pretty important, didn't you?
Right.
So
let's get into this document that I got and explaining habeas corpus stuff.
All right. Where should we begin?
I need to pull it up. I have it.
Sorry.
That one that I showed you before.
There we go.
This is the document here.
Did it work? Yep, it worked. Okay, good.
Yeah, you're good. That's only John's that does that. All right. So this is again in Kirk's Law Corner. It's the file is called Habeas Corpus, Writ of Liberty, Beaumodine, and Beyond. This is the name of the file that's in Kirk's Law Corner group. Okay. So this gentleman wrote this law in the Law Journal from this book. This is a book review. And you'll notice that there's 600 some pages of that. This is only a 12 or 13 page, 12 page document summary, basically a review. Okay. So if you really, really, really want to dig into this crap, go get this book. But for nearly, I'm going to make this even just bigger because I can see on my screen it's a little tiny. Oh, cannot quite get it in there. Oh, of course, then I went way too. So that's it, my in-between. Right. Okay, for nearly 800 years, the writ of habeas corpus has been a bulwark against the unlimited exercise of executive power, first in England and later the United States. Footnote number 1. Footnote number 1 says, the full name of the writ at issue is habeas corpus ad subjecendum et recipiendum.
Gesundheit.
It will be referred to as simply habeas corpus hereinafter for simplicity's sake, because I ain't trying to say that crap over and over again. All right.
Good, because I don't want to have to say Gesundheit every time you try.
Oh, Lordy. From 1219 to the Bush administration, the argument for a strong executive has been the same. Now, listen carefully. From 1219 to the Bush administration, the argument for a strong executive has been the same. Here is the argument that in times of crisis and emergency, it is the executive's responsibility to preserve and protect the homeland, even if that means curtailing personal freedom in the process. That is unlawful because no state of emergency can deprive fundamental rights, and that would be an attempt to alter the fundamental law. No, thank you. And this is the rebuttal to that argument. Such unchecked power, though, naturally threatens the foundations of liberty. And justice comes before liberty. That would be the maxim of law. So we got to have justice first, which is the law, jurisdiction, and the words of that law. Liberty, in its fundamental principles of law and the definition of liberty, is freedom from governmental restraint and intrusion into the lives of us, the people. So, threatens the foundations of liberty upon which a free society is built. That's right. With the Declaration of Independence, the Lee's Resolution, right? The Lee's Resolution is the political separation from the monarch. We no longer have that form of government. We declared ourselves as a free society. And over the centuries, England and the United States have grappled with this balancing act. What was it that I was reading in there? The bulwark of, from President Trump, reestablishing the rule of law, and what Madison said? That they would take power where it's not supposed to be, and that's just how it is. Because of everything they went through, they knew that that's how despotic government works and how tyrants work.
Which is also ironic as to why it's the first fundamental principle in group decision making, right?
Right. Over the centuries, England and the United States have grappled with this balancing act, which is mirrored in the evolution of the writ of habeas corpus itself. Ultimately, after 500 years of development. So I would say all arguments have been exhausted when it comes to the right of writ of habeas corpus. Habeas corpus evolved into a robust check on the Crown's power to arbitrarily detain. Arrest and detain are synonymous. They mean the same thing. So when these jackwagons out there in their disguise, when you ask them, am I under arrest or am I free to go? Oh, no, I'm just detaining you. Sir, detain and arrest are synonymous. Am I free to go or am I under arrest? What articulable and reasonable suspicion do you have that I have committed a crime that is an arrestable offense without a warrant? See the treaties on arrest and false imprisonment. That is for high crimes, treason, and felonies that happen directly in front of them. Right? Which is what? Murder, rape, assault, battery. Those kinds of things have to happen directly in front of the man making the arrest. Okay? Because that's the common law. Where the law really is at, the law. It was deemed so critical to liberty that it alone among the great writs was incorporated into the U.S. Constitution. Number 2. Let's read number 2. The privilege, well, how can it be a privilege when it's a right? It used to be a privilege until it got put into the Constitution and named it as a right, retained by the people, which shall not be infringed, right? So, the right of writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. Okay, what are we talking about when we're talking about public safety, rebellion, or invasion? Well, the public safety may require it if you've committed a bunch of mass murders out there. You know, let's say you're what do they call them? Murders where they do everyone once in a while.
Serial killers.
Serial killer, right? Okay. Dead cereal here. We got some Cheerios and Rice Krispies.
Cornflakes and Cocoa Pebbles all over the damn place.
Right? So it's necessary for the public safety to make sure that this man or woman doesn't not get out of confinement once they've been caught. That would be the public safety may require it. Yeah, I'm going to go ahead and require, if you've got the evidence to prove that this guy or man, woman, whatever, has been committing serial murders out there, or even just one, right? I don't want that man or woman loose out here on the streets to commit the same crimes again, over and over again. Because murder could, right, imply the death penalty. So he might run. So we don't, for the necessary security and safety of society, we're going to go ahead and keep them locked up, and we're suspending the right of writ of habeas corpus for that reason. Rebellion, that's an attempt to overthrow our form of government. Gee, that hasn't been happening for 200 and some years. Well, at least the last 95, at least what I keep getting. That's just the way we've done it for the last 95 years. Well, I don't care if that's the way you've done it for the last 95 years. Are you openly admitting in court and on the record that you've been committing capital felony treason for the last 95 years? Which is it? It's unlawful to begin with. So that process doesn't exist.
Somebody's in big doo-doo.
Right. An invasion. Oh, gosh. What do we got going on down there at the border right now? That's an invasion. For the public safety, I think we need to lock them all up. That is an invasion. There's no other way to look at it. We're now at 76,000 people that have come across the border since January 1st. Think about that for just a few seconds, minutes, however long it takes. 76,000. That's not an invasion? Really? Let's look at it like this. Let's say 10% that we, statistically speaking, are murderers. Okay. So we're going to take 10 M&Ms. And one of them is poisonous. It will kill you if you eat it. And we're going to put 10 M&Ms in a bowl here. Now I'm going to ask you, how many of these M&Ms do you want to eat? Remember, one of them is poisonous and it will kill you. How many of them are you going to eat? I dare you. You're going to eat 1, 2, 3, 5, 9? You eat all 10 of them? This is the dilemma we have with letting those people in without due process of law, a background check, right? And then they have to prove that they're seeking asylum. That's that part of the law that Congress made, you know, under the Immigration Act. To seek asylum, you have to prove that you're actually in fear for your life and that all this stuff is bad down there. Prove it. You've been taught by somebody out there to tell us that, but where's your evidence to support that? Then, not only that, let's just go with a rough, and this is not true, don't quote me on this. I'm just going to say 60% of them are young, fit males between age 18 to 35. And it's probably higher than 60%, okay? I'm just going to go with 60%. Let's go with 50%, okay? Let's say 50%. So 76,000 people that we've brought in, half of them are perfectly capable of defending themselves and defending their nation, their country, whatever that they are from. Why are they not fighting back? And how many hundreds of thousands are still on the other side wanting to come over? Why are they not standing up against whoever these people are that they're trying to claim asylum from? I mean, seriously, let's go with 35,000 men march their asses back down there wherever they're claiming this corruption's at, and take care of business. How long would that take? And then everybody can go back home to their homes that they supposedly fled from because of this, whatever it is they're trying to claim asylum on, right? You go back and defend your own nation. Don't come here and demand our benefits and demand our money and demand that we provide you with food, clothing, shelter, medical care, and pay for it too. No, I don't think so. Especially when you could have sought asylum somewhere in between where you came from and the border, because Mexico offered asylum, but you refused, right? So now let's go back up here. 500 development, Habeas Corpus, unchecked. Arguably becoming the most important original human rights provision prior to the introduction of the Bill of Rights. Now let's get that again. Arguably becoming the most important original human rights provision prior to the introduction of the Bill of Rights. Now, what is it that I've read right out of the Mason's Manual, section 2 there? Constitutional provisions stand on a higher plane than statutes and are mandatory. The right, obviously a very important, the most important human rights of all time, of 800 years and 500 years of development, it's the most important. Why do we not know about the right of writ of habeas corpus, folks? Why don't we know that? Why do we know that right? Throughout much of U.S. history, habeas corpus has continued the English tradition of being a check on executive power, thus bolstering the separation of powers. In its most vigorous interpretation, habeas corpus is a right of personal liberty, the right to be free from arbitrary seizure and detention. Let's get these writ of habeas corpus done, folks. Attach it with a petition of remonstrance. Get this crap filed. But there have been many notorious episodes in which personal liberty has been sacrificed on the altar of national security, from President Lincoln's suspension of the writ during World War I, or during the Civil War, to President Roosevelt's decision to suspend the writ along with the West Coast of the United States during World War II. But you can't. Not on the people. Now, maybe the invaders, but not the people. More recently, the writ of liberty has been threatened again by the indefinite detention of alleged enemy combatants in the Guantanamo Bay, Cuba, as part of the Bush administration's war on terror under the Military's Commission Act of 2006. Oh, what was that? Once again, though, the writ of liberty has proven more lasting than a unitary executive. The Supreme Court in Hamden versus Rumsfeld, and later in Boumediene versus Bush, determined that detainees do have a constitutional right to habeas corpus, despite being foreign nationals held de jure, if not de facto, in a foreign nation. Okay. In its decisions, the court relied on a comparative analysis of the writ of habeas corpus in English and U.S. law that provide dispositive both to the future of detainees at Guantanamo specifically, as well as to the scope of habeas corpus as the writ of liberty generally. In an effort to better understand the convoluted history of this fundamental writ, this book review summarizes and critiques one of the few comprehensive contemporary accounts of the evolution of habeas corpus in England and the United States, entitled Habeas Corpus Writ of Liberty. Okay. English and American origins and development. Remember that 500 years of development? Right. It then focuses on how Justice Kennedy's majority opinion in the Boumediene, which came down after this book was published, upheld the finest traditions of habeas corpus as being a robust tool against unlimited executive power. right? They don't like our petition of remonstrance. Let's hit them with writs of habeas corpus. And so I'm saying petition of remonstrance, the complaint for the Joint Task Force on consumer fraud, and a writ of habeas corpus. We'll hit them 3 different ways, okay? The review concludes by arguing that procedural barriers must be lowered for the writ of liberty to reach its full potential as a guarantor of post-conviction relief for unlawful or arbitrary detention. And now this covers everything, not just incarceration. We have to understand the original intent of writ of habeas corpus is any act by the executive branch. Any act. Doesn't have to require the incarceration. Oh, we're not done yet, Carol. Don't leave yet. You're going to want to see this. Okay? You're going to want to see this that I have down here. Now, Amanda sent this to me through from Anwar Congress. Thank you, brother, out there. So I'm actually just gonna switch this. You guys can read this, right? This is a 12-page document, just a review on the writ of habeas corpus. So you can get a better understanding for this. And I put this out on my show before, but now I'm doing it in the episode, so it gets in an order here. In a chronological order, you know, what are your rights and how do you effectively defend them? This is where we're at the effectively defending them. But you have to know your rights. Okay? So we're going to get into this document template. There it is. And I'm going to critique this a little bit more and fix some of the fix some of the changes that are in here. Okay. One, you're not really going to be going to a court, right? Except for the Court of Justice in the legislature, where we take our grievances. That's where we go. We don't go to the judicial branch. We go to the legislature with our grievances.
That's where this is where we secure our blessings of liberty.
Yes.
That's what we mean when we quote the preamble to the Constitution. So just to kind of help clarify that with Kirk a little bit, that's why we go to Congress.
Mm-hmm. Notice for non-statutory writ of habeas corpus is secured under Article 1, Section 9. And for the court to take judicial notice of the evidence of adjudicated facts are introduced into this court as evidence under federal rules of evidence. Imagine that, under Rule 201D, in support of writ of habeas corpus. Oral presentation before court is required on date of this filing. Because what is a writ of habeas corpus? Bring corpus, bring the body. Habeas, paperwork. So bring not only the body, but your paperwork to prove that however you're depriving liberty of this man or woman was lawful, not legal, not under policy, not under statutes, but in accordance with the law.
Were you wanting to share that? Because you stopped screen share, so.
Oh, I suppose I better do the screen share. Thanks, brother.
Whoops.
I'm looking at it. Why aren't you guys looking at it?
I don't know, George.
Gee, George, which way did they go? Okay, here we go. We're bringing that sucker up. How about that? Now you can follow along. See this document template. So I will get these uploaded to Kirk's Law Corner here shortly, because I know people are chomping at the bit for a writ of habeas corpus document template. Notice for non-statutory writ of habeas corpus is secured under Article 1, Section 9. That's right, because Congress shall be making no law. This is a right retained by the people that's 800 plus years old and has gone through 500 years of deliberation on it. it's well settled that is a right retained by the people to what? To thwart tyranny and deprivation of the right of liberty, coupled with the treaties on arrest and false arrest imprisonment. You knock this sucker right out of the park, folks. Okay.
Would that be one of them malicious designs that must be thwarted?
Yes, sir, indeed. I would have to agree with that. I would concur. So, guaranteed right, file a writ of habeas corpus in response to any act or acts consistent with restraint or oppression in state courts by defendant, and therefore this court must take judicial notice of the adjudicated facts. Okay. Under federal rules of evidence, as evidence before this court that the court is without discretion to act inconsistent with the adjudicated facts by the Supreme Court in support of this writ of habeas corpus. The petitioner on the date of this filing is requiring an oral presentation before the court to verbally, let's get through this. The evidence on the bottom of the page, one of the child support order. Okay, this is more specific for the child stuff. Okay. And I already changed that. They had in here the 14th Amendment. I switched it back to the 5th Amendment. The petitioner's right to life, liberty, and property, which comes from the 5th Amendment, not the 14th. Okay. Secured under the law of the land, which requires a trial by jury, appears under the 7th Amendment for a controversy of $20 or more. This would actually be wrong, right? Because that has to be criminal in nature. So it wouldn't fall under the 7th Amendment. That would be the 4th, 5th, and 6th Amendment. But this is why I'm saying I'm going to have to critique this and make changes. The evidence of an alleged child support order marked Exhibit 1 as causing the petitioner type in your name, blah, 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 an aggrieved natural individual who is restrained by a judgment, not by peers. Didn't go through a criminal process, right? To deprive the fundamental right lawfully, in accordance with the law of the land, the process that is due. Without a waiver of rights, the evidence of a judgment not by peers is clear and convincing evidence before this court of a violation of due process. Yeah, that's clear and convincing evidence. Well, was there a trial by jury and you got the consent of all 12 of his peers to deprive him of that fundamental right? Well, no, that's prima facie evidence you violated due process. You're done. You're burnt. It is an adjudicated fact that without a waiver of rights, any summary judgment without a judgment by peers is void for violation of due process under the law of the land as prescribed by the Supreme Court of the United States.
Hey,
the
question.
Judgment of his peers or the law of the land.
May I interject there real quick?
Yes, sir.
What right does anybody have to ask you to waive your unalienable rights? Just one of them conundrum questions. You know how I love to ask them. So
right. But what you have here is you have two parties, at least a minimum of two parties, one plaintiff and one defendant. If they want to, talk to each other and work this out a different way and not go to a trial by jury, that's fine.
So that's arbitration. So, but
bingo.
That's again,
right.
This is where they catch us on this word salad, which is kind of where I was going with this.
But it has to be, like I've showed before, this has to be in writing that you're waiving the right. Because this is where it's backwards. Because first, in my rules of procedure, and I'm sure everybody else says the same thing, oh, you have to do a notice of demand for a trial by jury. No, that's pursuant to the law of the land. I already have that right. And it says shall be by trial by jury.
Right.
So it shall be by trial by jury unless I waive that right.
And again,
in writing and in court and on the record. And by stipulation, I hereby stipulate that I waive my right to a trial by jury. Otherwise, it shall be by trial by jury.
In other words, anybody who would waive their unalienable rights is not competent to stand trial by technical definition, because why in God's creation would you waive a right that's guaranteed to you under the law?
Right. There must be some sort of mutual benefit there.
There
At
you
least
go.
in my mind, right?
Keep going. I know where you're headed. Keep going.
8 elements of a lawful contract.
There you go. Now you're
Mutually
talking.
beneficial. If where we can work this out through mediation, or the technical term would be arbitration, depending on the
Agency,
situation.
right? You can enter into a contract which has a mutual benefit, right? Okay.
Right. Meeting of the minds, it's mutually beneficial, and we're all okay with that. We can go ahead and waive that trial by jury and just deal with this over here on the side. We don't need the court for that. It is an adjudicated fact under the Penoyer rule, whatever that is, versus Neff Supreme Court. That's a new one to me. That any judgment issued in violation of due process of law is void from the beginning. Yeah, Marbury versus Madison as well too, but that would be statutes, I guess. Process, Title 5, 556, and 557. If you violate due process of law, they lose all jurisdiction. That may be where that comes from. Okay, so there's a really good case. The adjudicated fact in Meyer versus Nebraska, 1923, is evidence that this court is without discretion to require the petitioner to be physically restrained as required by the state statute. It is an adjudicated fact under Harris versus is before this court as evidence which requires that this court must recognize that the great writ, and it is true, like I showed you there, it is a great writ. Writ of habeas corpus is a constitutionally secured right under U.S. Constitution, Article 1, Section 9, that can be utilized by an aggrieved individual to challenge unconstitutional actions and deprivation of rights in state courts, and state courts cannot deny writ of habeas corpus by citing state legislature confining remedy to only physical custody, when the Supreme Court held that it can be utilized to challenge unconstitutional acts in state courts, as in this matter. Again, like I said, writ of habeas corpus is any act that deprives you of your liberty, deprives you of your fundamental rights to due process of law. Okay? The writ of habeas corpus is the fundamental instrument for safeguarding individual freedom against arbitrary and lawless state action. Its preeminent role is recognized by the admonition in the Constitution that the privilege of writ of habeas corpus shall not be suspended. Yeah, I know that, right? Its ability to cut through barriers and form and procedural mazes. You will find that in that liberty of Boumediene. Okay, that cuts through all of that. That actual phrase, I believe, it's been a good probably 8 months since I've read that, and I vaguely remember that actually being in there. So, have always been emphasized and jealously guarded by courts and lawmakers. The very nature of the writ demands that it be administered with the initiative and flexibility essential to ensure that miscarriages of justice within its reach are surfaced and corrected. Bring the body now and the paperwork to prove that you have lawful authority, that you lawfully deprived these rights and you followed due process of law, the process that is due. And if you can't, that's a do problem, right? You done that. Shouldn't have done that. Jackwagon. So when it goes through that process of habeas corpus, and let's say your children have been kidnapped and you know that you got evidence and all this stuff, you do this writ of habeas corpus and you submit your evidence, right? They have to bring your children there because that's the body of the crime, the bodies that they have seized unlawfully. And then when they go through the hearing and they can't prove that they followed the law of the land, because why? Because the Idaho Code's not law. Get that color of law crap out of here. Here is the law, the Bill of Rights, right? The Declaration of Independence, the Constitution of the State of Idaho and its Bill of Rights. That's the law of the land, not that SMU.
There you
Get
go.
that crap out of here.
That's right. Kick rocks, buddy.
Kick rocks. The very nature of the writ demands that it be administered, right? Demands. As Blackstone phrased it, habeas corpus is the great and effectuous writ in all manner of illegal confinement. All manner. Well, that's taking your children. That's an illegal. That's an unlawful confinement, right? Who are you to take my children without lawful standing, lawful authority? That disguise doesn't grant you special privileges. Oh wait, yeah, it does. But it doesn't grant you to what? Because all men are created equal, and no man is above the law, and the statutes are not the law.
Well, and it doesn't give them the right, and anybody the right for that matter, to either act outside or above the law and violate a person's right, which is kind of where that legal maxim came from. What I cannot do in my person, I cannot do through the agency of another.
So here's right here, Claire. It's like going for surgery without a surgeon. It should be a law that if one cannot afford counsel, especially when children's lives are involved, it says we have the right to the assistance of counsel. It does not say that you have the right to an attorney. And if you can't afford one, one will be appointed to you. No, that's the SMU that comes from the code that says, oh, well, you have this right. And we know that you do. And we're going to play the confidence man, confidence game, the confidence trickery, the confidence scheme, scam, and fraud. And, well, we're going to prey on your ignorance. And we're not going to allow anybody else in here unless they're from the bar. You may have the right to the assistance of counsel, but, we've converted that right into a privilege, licensed it, and attached a fee to it. And yet we don't even frickin' issue a license. We issue a membership card. You got to be a member of the American Bar Association in order to practice their law.
My library card has more standing in court than that damn bar card does. Sorry. Just saying. By the way, did I get a chance to tell you? It's already coming out that states are finally starting to get the hint about this quote unquote bar association, right? Enough
Nice.
people have challenged it, and it is getting ready to head out the door. In other words, these attorneys are going to have to prove status, standing, and jurisdiction.
Bingo.
Before they can even get a case number.
Yeah.
It's kind of the scuttlebutt that I'm catching. So,
Claire, I want to clarify this, that one should be appointed. No, it's a right retained by the people. That means it's your choice. The claim and exercise of a right cannot be converted into a crime. Okay. Now, again, I've tried it twice this last week, Thursday and Friday. Both times got shut down. Don't have your license, blah, blah, blah. But I informed the judge, hey, I'm an agent of E-Clause. We were created by the consent of Congress. That's the license you're looking for? Schwer versus Board of Examiners says that no state can license the practice of law. Sims versus Ahern says that the practice of law is a common right retained by the people or held at the common law. That's right. Because it says that it's a right retained by the people. That is an enumerated right. And Congress shall make no law. You don't have the authority to change right back to the fundamental principles of law, right? These are principles in the Bill of Rights. But this is why they try to say, well, the Bill of Rights doesn't apply to the states. Really? Well, see the 10th Amendment, because it sure in the heck does. And not only that, let's read the top portion of the Bill of Rights that nobody wants to seem to publish, which is these are articles in addition to, as an amendment of the Constitution. Because they didn't actually amend the Constitution. What part of the Constitution did it amend? Oh, that's right, it didn't. That's why they are articles in addition to, as an as an or as a amendment. It says as a amendment. So it's one amendment to the Constitution to add originally 12 articles, but only 10 of them passed. Originally was 156 articles that were proposed, narrowed down to 12, and then ratified to 3 through 12. The first 2 didn't get ratified. That's what created the Bill of Rights. So in reading the Constitution, it should say in the end of the Constitution where it says Article 7, we should go on into Article 8, Article 9, Article 10, or as a separate complete document attached to the Constitution as a amendment, as a Bill of Rights, Article the 1st, Article the 2nd, Article the 3rd, because that's what my certified copy of the original 12 amendments that were proposed is written. It says Article the 1st, Article the 2nd, Article the 3rd, because they are articles in addition to the Constitution. So
let me ask a question here, because you bring up a very, very interesting point. Now, when we write real estate contracts for those types of transactions, what we do when we run across conundrums like this, we don't alter the original contract. What we do is we file addendums or supplements that go with the original, and those supplements and addendums explain what why it is we are adding this extra provision, but you don't alter the original. Does that make sense?
Yeah.
So in other words, it's a check and a balance for us to be able to go back through and say, oh yeah, that's right, we did that in here because we discovered there was a defect or a deficiency or some non-latent defect came out that required this addendum or supplement, some form of disclosure, for example. But the original document never changes.
That's
and
right.
because that we're starting to see that a lot of these additions in the forms of amendments, well, you don't need an amendment. What you need is either a supplement or an addendum, right? An addendum is a correction, an error correction, and a supplement is something in addition to the original document that cites the specific cause. So that's why I just wanted to throw that out there, because it's
that's a good way to explain it.
Mm-hmm.
Yeah, and see, through history, again, understanding, comprehending here, a Bill of Rights was usually written first, right? Because you have to lay down the law. You have to declare the law, your rights, the actual law, and what society deems to be intolerable restraints. You do that by laying down, because law is that which is laid down, ordained, or established. Clearly, the preamble to the Constitution of the United States of America says it's ordained and established. Okay. My state constitution in the preamble says that it was established, right? We, the people of the state of Idaho, grateful to Almighty God for our freedom to secure, again, to secure its blessings and promote our common welfare, do establish this Constitution. Now, what's the first thing you read in your state constitution? Article 1, Declaration of Rights. Because you have to lay down the law first, and then you create the government. That's the way it's worked for a long time. Now, what happened there with the Constitution is the Constitution was only supposed to solve 2 problems: commerce and war. And how are you going to pay for the war? Commerce. That's actually been written in history, starting as far back as I've read, laid out in America, North America here, was the Second Charter of Virginia in 1609. talking about corporations and how talking about how it's already worked for a while, right? How they charge fees at the ports, importing goods. There was a fee charged. This is how they were to make the money. This is clear back in 1609. It's the same way, right out of the Constitution of the United States of America. Taxes, imposts, duties are supposed to be laid at the ports of entry for those acting in foreign, right, interstate and foreign commerce between a state and a foreign nation, and the Indian tribes and a foreign nation, not between the people, right? Not between me and Chris, not between me and Joe Schmuckatelli over across the street here mowing his lawn, okay? That's not commerce, and that's not income. It is not taxable. And again, show me the law that says we have to pay tax. Doesn't exist. And I posted that. I've shared it. Already posted that out there. That's actually taxes too in there in a file in Kirk's Law Corner. You can go read all about that. So let me finish up this doc here. We've run over time, but worthy of explanation. The office of the writ is to provide a prompt and effectuous remedy for whatever society deems to be intolerable restraints. Now, what we're talking about there, what society deems, well, that would come from the law of the land, because the people establish justice, not government. And society deems the unlawful restraint, if you violate the Fourth Amendment, that's an intolerable restraint. Sorry, you lose, because it's in writing, and ignorance of the law is no excuse. Your statutes are not the law, and the legislature does not have the authority to alter the fundamental law or the Constitution. You can make amendments to it only under Article 5 Convention, and that's only the Constitution of the United States of America. Again, under what jurisdictions? Admiralty and maritime law. That special maritime jurisdiction, right? Those two jurisdictions that was delegated to the federal government, that would be out on the high seas, the navigable waters, in an airplane, transporting goods. Okay, C. Payton versus Roe, 1968. So that's actually somewhat of a newer case. Harris versus Nelson in 1969. So clearly these are new enough, although writ of habeas corpus has been around for 800 plus years. I don't think we need to rehash the right of writ of habeas corpus and what its intent is. It has effect, the judicial officer hearing this writ of habeas corpus is bound to act in accordance with the law of the land under the Supremacy Clause, Article 6, Clause 2, and any act not in pursuance of the law of the land is proof of judicial official. The judicial official has vacated the oath of office, and any judgment is void. That would go back up to these. Okay? So now, it is an adjudicated fact before this court, secured by Supreme Court matter Miranda versus Arizona, that this court cannot dismiss this writ of habeas corpus to challenge unconstitutional acts in state court by citing a state law or court rule that denies this right for writ of habeas corpus secured by the Constitution under Article 1, Section 9. Which I could probably go back, I think it's Section 60 or something of the Magna Carta. Okay, it's been around for 800 years, folks. Magna Carta ain't even that far back. I mean, 1215, that's a little ways back there.
One or two, anyway,
That'd be right around 800 years, wouldn't it?
Yeah, ish.
That'd be put it at 2015. So 804 years ago is what we're actually talking about in the Magna Carta of 1215. I think it's Section 60. Secured by the Constitution involved. Okay.
One cigar.
There can be no rule making or legislation that which would abrogate them, or which would abrogate them. I think it's that which would abrogate them, but I could be wrong. 1966. Okay. So I'm going to go ahead and tidy this up because it's pretty close to the end here. And again, I'll get this fixed because in my mind, you're not supposed to be writing in all capital letters. That's dog Latin. You want to make the font bigger? That's fine. Make it bigger, but do not write in all capital letters.
Yeah.
That's not proper English.
Yeah.
This is the language of the dead.
Yeah.
Dog Latin.
Ig pay Atenlay, right? Big Latin.
Yeah, right. So here you have it, folks. I got something for you. I'm putting it out there. Here we go. 14th Amendment. Now, change that to the 5th Amendment. Equal Protection Clause. Life, liberty, and property is the 5th Amendment. They already covered that in the Bill of Rights. 14th Amendment did not add any new rights. Sorry.
Nope.
That's
that barrister crap they've been trying to shove up our ass for 200
years.
So anyway,
the evidence of the void judgment.
Should I make the announcement that John called us with earlier about Wednesday? Let everybody know what's coming. Get ready for a breaking news in Tennessee.
All right, hold on. Yep.
John
Here we go.
posted that, by the way.
Say again?
I said John posted that news, by the way.
He did?
Okay.
Yep.
Yeah, he posted it.
Did he post the link too?
I can't say for sure because I can't get there.
Okay, because when I got to hook up with him and see if we can get the announcement posted.
Yep, Malika.
For Wednesday morning. Wednesday morning, John is going to be, he was granted standing to testify before the Senate General Assembly, actually one of the committees, with reference to a bill that he believes is targeting his petition of remonstrance. And that would be a big time no. So because it's relative to the subject matter that we talk about here on the show, claiming and exercising rights that are guaranteed us, right? It's not just the Constitution, but remember, the Constitution is not just the document that creates government, is the document that limits government to the tiny little emoluments of their office. So the rest of this word salad, as we have literally regressed over time, we have actually devolved back into these same political arguments again. So, let's to avoid the conversation of cow farts and, relative other BS. We will be posting a breaking news when we'll take it live as soon as if the committee decides to broadcast it. That's another thing John's going to check out for us and make sure that it's going to be broadcast, so we get to listen to our brother go down there on the floor of the Senate, and he's got 4 minutes. He's going to have 4 minutes, so we got to make it a good 4 minutes, man. So
yep.
But I'm excited. I just want.
And everybody can do that. You just have to sign up and do a brief little written document on what you want to talk about. And you're able. This is open meetings, right? Open meetings law. They have to open it up to the public to testify and give reasons in front of the General Assembly, who's going to vote on that bill.
Well, this is
supposed to be.
Yeah, this is us getting involved in the process and doing it lawfully, right? You don't have to go in there and jump up and down and yell and scream and act stupid. Also too, I almost forgot. I wanted to welcome another brother in arms to the Dave Arndt from Oklahoma. Just entered his petition of remonstrance today. And Oklahoma is the newest state we can add to our arsenal. So
Yay.
they're starting to fall one by one. Dude, where are you at, brother? Why haven't you entered yours in yet, man?
You know why.
Well, you know,
I need help.
You know, I love you.
I know.
So,
Too busy out there helping everybody else with theirs.
well,
That's
you know,
part of it.
that's what it
So, given that, if you enjoy the shows here and you're learning stuff, and you want to help support me, I would greatly appreciate any personal private donations. You can send those donations to me through PayPal at Kirk_Pendergrass@hotmail.com. It's just my name with an underscore in there in between at hotmail.com. For those of you who remember Hotmail, had that sucker forever. The address for the office, 6477 West Fairview Avenue, Suite C. That's Charlie. Boise, Idaho, 83705. If you'd like to send a postal money order, cashier's check, regular money order, personal check, or cash even. So wrap that stuff in aluminum foil, right, Alan? Good job, brother. And yeah, I greatly appreciate the support that I've been getting. I applaud y'all for supporting me here, paying the bills, man. Got to pay the bills to keep this stuff going, and support the office, support everything it takes to run everything here. Internet, Zoom costs $55 a month. Internet's $40 a month, and yeah, all the other good stuff that comes along with life. So I appreciate your support so far, and please make donations to help support me keep this going. So yeah, I'm going to keep Zoom open for a little bit. So if you want to join us here on the after show, you're more than welcome to. Can maybe address some of your specific questions with the subject matter of the show tonight. Please do not try to come in there and trying to tell me your story about your case and how you got the best case out there and nobody else has any. You got all this evidence. Everybody's got their hundreds of thousands of cases just like yours. This is the reason why I'm providing the education here, to educate you so that you can stand up for yourself. Because literally, there are way too many people out there that are being victims of all this stuff than I could possibly get to in a lifetime. And I'm already 47, close to 48. There's no way I'm getting to all of your cases. So this is why I set up Kirk's Law Corner the way I did. First, it was Law for Dummies, right? Blog Talk Radio 2.5 years ago. So got to learn this stuff for yourself. There's nobody else going to be able to do it for you, right?
That's right. And as we move forward too, and we start getting some, cooperation through the legislators and those types of things. Remember our little 15 minutes of shame that we were doing. I would like to reintroduce that as a 15 minutes of fame type of thing and be able to, call out the good actions, and emphasize more the good actions than the bad actions. There's plenty of people out there doing the bad actions. So, if you do happen to run across somebody whom we already know or who is attempting to, right the wrong, don't be afraid to thank them, right? It's a very simple gesture, and it means more than you'll ever know. So with that, I think we pretty much killed it for the rest of the night, and we're ready to go for Wednesday. What do you think, brother?
I think we're ready to rock for Wednesday night. I cannot wait to hear back from John.
Yeah.
So hopefully it'll be streamed live, and I will record it if it's out there. I will record it. So
all right, everybody. Hope you guys have a wonderful night and Tuesday and on into Wednesday, and we will see you on the Wednesday night show.
Much love, folks. See you Wednesday night.